afternoon. Welcome to the July 2023 session of the Board of Zoning Appeals. Madam Clerk, if you would please give us a roll call.
Curtis Brown.
Present.
Jonathan Repass.
Present.
Doug Lloyd.
Present.
Garrett Holt. Cecil Anderson. Terry Kerr.
Present.
Sherry Garrett.
Present.
Rebecca Longmire.
Present.
Paul Huff.
Present.
All 9 members are present.
All right, and Ms. Longmire, if you would please lead us in the pledge.
Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you.
Members are volunteers from each commission district. We do not receive compensation for our work on the board or training that we attend. And as a quasi-judicial body, we avoid ex parte conversations and conduct our business in accordance with the Open Meetings Act. My name is Terry Kerr. I'm the chair of the board, and to my left is Rebecca Longmire, the vice chair, and to my right is Mike Moyers from the law director's office. Steve, where are you? Oh, there you are. You're in a different chair today. Where were you? If you would please let us know who's with you today.
Yes, Steve Elliott, Kelly Vaughn, Kim Jarnigan from our codes office, and then from Knox Planning, we have Lindsay Crockett, Michelle Portier, and Naomi Hanson.
Okay, thank you. Our voting procedure requires 5 positive votes for a motion to be approved, regardless of the number of board members that are present. And today we do have 9 members present. If I could please have a motion to approve the previous month meeting.
So move.
Second.
Okay, motion carries, or all in favor, I'm sorry, all in favor? Aye.
Aye.
Opposed? Now the motion carries. All right, the Knox County Board of Zoning Appeals is authorized to grant variances and hear other matters by the Tennessee Code and the Knox County Zoning Ordinance. Specifically, these laws prescribe parameters required to grant a variance. The burden of proving the grounds for a variance request rests upon the applicant. For each matter, the clerk will read the request into the record. I will then ask if the applicant is present, and then I'll ask if there's opposition or other speakers who wish to present. You don't have to come forward at this time. Once we determine the speakers for the item, we'll call on the governmental agencies such as Knox County Codes, Planning, or Engineering to make statements regarding the facts pertinent to the property and background of the request. Board members may ask questions of the governmental agencies once they have made their statements. Then I'll call on the applicant to come forward, state your name and address for the record, and present your evidence and reasoning supporting the granting of a variance. If there is no opposition, the applicant has 10 minutes to present their case. If there is opposition, the applicant and opposition will each have up to 15 minutes. After the applicant's presentation, board members may ask questions of the applicant. Then I'll call for opposition or other parties who will have up to 15 minutes to speak. This 15 minutes applies to all parties, so if there are multiple parties that wish to speak, please determine how you're going to divide your time beforehand. After the opponents speak, the board members may ask questions of the opponents. And finally, there'll be a discussion of the case by the board, during which time board members may ask further questions of the parties that have already testified. Then the board will make any determinations it deems necessary. Our bylaws allow an applicant at the initial hearing on a matter to request a deferral of 30 or 60 days without prejudice. In the event of a deferral of an application or failure to appear, any opponents may be heard on the record at a meeting where the application they oppose appears on the agenda. All right, Mr. Moyers, if you would please swear in anyone who would like to testify.
All right. If you're here to speak to this board either for or against any item on the agenda, if you plan to come and speak to this board, if you're an applicant and wish to have your case heard, if you're in opposition and you plan to speak to this board, please stand and raise your right hand. You solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God. Be seated.
Okay, and we were discussing some agenda changes or corrections.
Yes,
Steve?
item 4B, the developer has opted to take that case to court, so it has been removed from the agenda.
4B? Okay, 4B is removed.
Item 5A has requested another 30-day, deferral.
Would we vote on that now as to whether we would want to grant that deferral, or would we wait
Yes.
until the end? Okay.
You can do it now.
So if someone would like to move,
I move to make a motion that we dismiss this based off of 4 continuous referrals, failure for subject to show up.
Second.
all in favor? Aye. So moved. 5A is dismissed.
Dismissed, yeah, it's removed.
No, it's not deferred. Okay, Madam Clerk, if you would read 4A, our first agenda item.
4A is a request of Brandon Arnwine. It's for waiver of a side yard setback from 10 feet to 6.98 feet. Property is located at 7911 Thorn Grove Pike, CLT map 85, parcel 19205, property zone agricultural in the 8th Commission District.
Okay, is the applicant present? Is there any opposition? Okay, if the applicant would come down, if you would, to the podium. Do we have any statements from Knox County?
Not at this time. We're available for questions.
Okay, if the applicant would state your name and address for the record.
My name is Brandon Arnwine. I own 7911 Thorn Grove Pike.
If you could give me your reason and your evidence supporting your request for this variance.
I would like to request a waiver on the side setback requirement of 10 feet to 6.98 feet. As you can see on the plat map, the surveyor used a cedar tree to mark an inside point of the line on the left side of the property. That's actually the upper part right there. You can see it says 16-inch cedar. During excavation, the cedar tree had to be removed and therefore the boundary marker was lost. There is a pin that marks the corner near the driveway right there, and as you can see, that line does not go straight out from there. It goes in towards the missing cedar tree and then back into the woods. This was another reason that the encroachment occurred. The adjacent property right there in the upper left, you can see there's no permanent structures.
And you haven't had any opposition from your neighbors? They know what you're doing? Any questions from the board? This is in Ms. Longmire's district.
I'd like to make a motion then to approve the waiver of a side yard setback from 10 feet to 7 feet, we rounded up to the nearest decimal, due to an oddly shaped lot which would prohibit the applicant from making best use of this property.
No, I second that motion.
No.
Pull your mic down. Thank you.
I understand the desire to round off to the nearest foot, but my concern is if a surveyor has determined this, did your surveyor determine the current setback, 6.98?
Yes.
Then if it's 7, if we give him 7 feet, then he will still be, I understand it's only 200ths of a foot, but still, I think it would be better to go to 6.5 or 6.7 so that he's got, I guess, a little room. If we make it 7, he's
Still too close.
He's making it tighter, is that what you're saying?
Yes.
Okay.
Yes, if we make it 7, he's still too close. We need to make it 6.
6, okay, we,
All right.
yeah, we discussed that a little backwards, I think.
Yeah.
Okay,
Okay, so I will change my,
thank you.
to change it, the setback from 10 feet to 6 feet.
Again, I second.
Okay, revised motion to approve from the 10 to 6. We have a motion and a second. All in favor?
Aye.
Opposed? Thank you for that. Motion carries. 4B has been removed. Madam Clerk, if you would read 4C.
Don't we have to vote to remove something from the agenda?
Well, by operation of the ordinance, it comes off. I mean, you could, even if you voted not to take it off the agenda,
But we
it's
have-
still removed from your jurisdiction. So I don't think you need to vote to take this one
Okay.
off.
We voted on one similar to this once before to take it off the agenda.
If you want to vote on it, you can. I just don't know that you have the right to say no.
Well, I would say we don't have the right to say no. Okay. It's already removed, yes. Yeah, we've already removed it. Okay, any other questions on the removal of 4B or questions regarding the removal of 4B? Okay. All right, Madam Clerk, if you would read 4C.
4C is a request of Joseph and Donna Denton to appeal building permit number 23-1577 for cell tower. The property is located at 11445 Sam Lee Road, CLT map 103, parcel 053, property zone agricultural in the 6th Commission District.
Okay. Do you want to?
Okay.
Tell me which direction you want me to go first. We can do our applicant in opposition.
I think, why don't you?
Okay. Is the applicant present? Okay. And we have opposition? Is there opposition present?
We're the opposition. We're the opposition, I'm sorry.
Well,
Well, and for
Yeah,
the
it's a little
purposes
back.
of this proceeding, you're the actually the applicant because you've appealed the decision.
The decision,
So you're the applicant and this gentleman would be the opposition to the appeal. So,
that is a little confusing. So if,
Can everyone turn up the volume just a little so we
we have to have it close to our, everyone just talk real close to the mic. It's very difficult to hear, I do know. Thank you for that.
we're quite elderly out here.
So are we.
so are we.
Yeah. We are all on the same page. Okay, so we have the applicant is present, and we do have opposition, so I'm sure there is some, a representative for the applicant. If you'll come forward.
15 minutes.
Yes, keep in mind you have 15 minutes.
Total.
Total, so you can share that. When we're speaking back and forth and asking questions, that'll kind of be cutting off your time. But as far as when you're starting to speak, then you're going to be on time. So if you would please state your name and address for the record.
My name is Rick Cheverton. My address is 11733 Couch Mill Road. Not sure what happened to Joe. Here he is.
My name is Joe Denton, 11780 Couch Mill Road.
Okay, and if you would please, let us know why you're
Why we're here.
Yeah, why you're here.
All right, well, we appreciate this opportunity to present our concerns surrounding this. First of all, what we'd like to state is we understand the need for cell towers and how applicable they are to people's safety. And, you know, wireless providers provide what used to be landlines for people, and so in cases of 9/11 and et cetera, they are a necessary thing. And we are not against a cell tower being built in Hardin Valley. What we are against is the fact that it's being placed on the piece of property that it is being placed on. One of the first things I'd like to say is you look at this map up here, and I have another map like this that actually shows it a little bit differently, but here's the piece of property where the cell tower is actually going. This is all planned residential. I mean, actually would connect to the property if the road were not there. There's 175 homes getting built in there right now, and there are additional homes that would be built on the property they've already purchased back here. This also is all planned residential in this area back over here. So although this is agricultural zoning in here, every piece of it has a residence on it. This is a residential area. Yes, it is zoned agriculturally, but from a standpoint of what's going on that piece of property, it really is in a very residential area. If you look at the uses of an agricultural zoning and go strictly by that, then they could go in there and put a hog slaughtering farm on that. It is a use in an agriculture farming for slaughtering of pigs, chickens, and just about anything else. It is a use without a use on review. When we first saw this property being staked out, we called the plans review office and asked about it. And at that point, they didn't even have any information on it. So I assured people in the neighborhood that it wouldn't matter because when it was posted, they would have to post a use on review, that surely the cell tower would be a use on review. We would have an opportunity to come up here and voice our objections to it and present, why we did not feel like it's fitting in that, situation. So I called Kim Jarnigan and actually called her office up there. And Kim was very helpful through this whole process, but informed me that no, there is no use on review required anymore. The cell tower is actually a use permitted in an agricultural zone piece of property. And so I said, well, what are our options then? She said, well, the building permit will be approved, assuming that they have all essentially their I's dotted and their T's crossed. But your option would be to appeal it to the Board of Zoning Appeals after the permit is approved. And so I argued the point, not argued it, but I asked her, I said, well, I want to make sure we don't miss that window because I travel a lot and a lot of my friends travel also. So I said, I would like to go ahead and fill the paperwork out for this appeal. And she checked with, I believe it was the attorney for Knox County, and was told, no, you cannot fill the appeal out until the permit is actually issued, or approved. Not issued, but actually approved. And so we had to call essentially on a daily basis because we only had 15 days, we were told, from when the permit was approved to file our paperwork. And Kim said she would have that paperwork available to us and that, it wouldn't be an issue. But yes, we would have to call essentially every day to find out when the building permit was actually issued. And so we called their office, or approved. So we called their office constantly to find out when that was be, and we called the day it was actually approved, and Joe Denton came up here and got the paperwork and filled it out. So that's the process we were told to go through to appeal to the Board of Zoning Appeals. The property really, as I've shown you, is actually, in fact, there's the map right there, which is the same one I've got right here, is in a residential area. And our appeal here is that this essentially, even though zoned agriculturally right now, it's a residential area, very, very much a residential area. So 4.9.2 standards for wireless communication facilities. The purpose of the section is to create a legal framework for the siting and appearances of wireless communication facilities throughout regulations or through regulations that will. And then it goes on to state, promote and protect the public health, safety, and welfare, and preserve the aesthetic character of the community. And I know that this board, as well as NBC and the other boards here, first of all, you have to make sure that everything is being done according to the regulations and codes that are set forth. But one of the other things that you obviously have to do is make sure that we as a community are being protected, not only for our safety, but also, as it says here, for the aesthetic improvements in the community. And so that's where we are coming from on this. When you come up Couch Mill Road to Sam Lee up there, it's a hazard, a traffic hazard for people that are, when you're coming, traveling west on Sam Lee Road. And I don't know, there are several studies that are on here that talk about that the provider has got to do for his application permit. Some of the studies that weren't mentioned here, and I would like to know was done, was a traffic study was a traffic study done because the line of sight right there, when you're looking east at the traffic coming up, there was an accident there the other day, and which is not uncommon because you don't have very much time to respond when cars are coming up that hill right there. And with the setbacks that this has and the trees that are planted around it and everything, is that going to interfere with that? I don't know. I can't tell you whether it will or not because I haven't seen a traffic study. That's another problem with this not being posted. We were never given opportunity to see the permit the permit process that was turned in. So until today, I haven't seen A, the building permit, B, their drawings, and C, their studies. So I'm just now beginning to actually be able to see this stuff because it was never posted. We were never told that was even available. The one thing I did notice, and there are a couple of things, they state in there that, you know, this is unusual in its height, that it's shorter than most cell towers like this, which is not an accurate statement because even in an agricultural zone, you're limited to 125 feet. This tower with its antenna on it is 124 feet. So it's already maxed out. You can't have a taller tower in an agricultural zone than what they're actually doing there. Anyway, and there are a few other things that I saw on there that I would take issue with. Another thing on here is, you know, one of their requirements is there to check with, you know, other surrounding areas, and they're turned out, I think it was a minimum of 5 other places that they checked, and were not able to put the cell tower, and they've got to provide reasons that they weren't able to do that, and so on and so forth. If we had been notified in advance on this, and we had had time to be a part of this process, then people in the community could have also been a part of finding an alternate site to put this on that would have been a whole lot more applicable. I know you have a responsibility to uphold the zoning law and zoning ordinances, but I think that this is very valid, that this does not fit in this you know, residential area, even though the site itself is zoned agricultural. Also, the number 3 on that is to protect residential zones from excessive development of WCFs, and that's what this is, the wireless facility, by ensuring the towers in or near this area are only sited when alternative facility locations are not feasible. We don't know, just because they turned in 5 different places that they went to, that there are not feasible alternative locations. We have not had time to research this. There's a U.S. cellular tower, 3,700 and so many feet from this tower. The first thing they're supposed to do is find out if they can I forget the terminology.
Co-locate.
Thank you, co-locate. To see if they can co-locate with another tower. There is a tower that's, like I say, only 3,700 feet away. Have they checked with them to see if they could, you know, piggyback onto their tower? Also in that, it's in these regulations, it says, even if that tower is at the maximum height that is allowed, they will allow them to extend that another 10% if it makes sense that they piggyback onto that tower. It also says that even though that tower and those facilities may encompass all the ground cover that they're allowed to on their original application, that can be expanded also if it's shown that it would reduce WCFs in that area, if it is feasible to actually put it onto that tower that's already there. And then it goes through some definitions of what a tower is. This is obviously a tower, wireless communication facilities. It goes through here, just refers to them as WCFs, which makes it a lot easier to talk about. But then down at the bottom of 4.92, it says it's a statement of preferred locations. There are preferred locations for WCFs within these regulations. It says new towers located in the preferred ranking list, and new towers new towers sited in the least preferred location shall require review by Planning Commission. One of the other problems with this is that this didn't
I
require.
just wanted to let you know you're a little over 10 minutes just to give you your time.
I'm not going to finish.
You're
you know, and
good.
that's a problem with not having
Just keep
before
going. You're
been
good.
able to present this.
No.
I don't have time to.
You just keep going. You're good. I just wanted
Okay.
to kind of tell you where you were because we're marking down questions for you.
I
so you just
appreciate
keep
that.
going.
So anyway, one of the problems with the current way the zoning regulations are is that this does not go before the Planning Commission. This goes before a designee by the Planning Commission to review it. You know, that's the way it's written right now. But and I'm going to get to in a minute what our preference would be, even though that's not the requirement right now. But if you go through these, and it goes through the Planning Commission, it ranks where these towers should be able to be built. Number 1, where they're preferred, is an industrial zone or business park. Hardin Valley is full of industrial zones and commercial zoning all the way down Hardin Valley. which would have been the preferred place for that. And there's all kinds of corner lots on, say, perhaps Food City or others where this tower, where they could have negotiated, and I guess maybe it was too expensive for them, but they could have negotiated a place to put this. B is a commercial or office zone, also of which there are plenty of in Hardin Valley. And then C gets to other zones, okay? So you're getting down towards the end. You got C and D down here. C includes the agricultural zone, which is what this actually does fall under. D is a residential zone. And then it goes on to talk about or within 2,000 feet of a scenic parkway, or excuse me, highway, or Tennessee Parkway, or historic district. And although you're not within 2,000 feet of Pellissippi Parkway as a crow flies, the Pellissippi Parkway is a scenic parkway. It is a Tennessee State Scenic Parkway. So if it had been within 2,000 feet of that, they would have had to go before Planning Commission also. And then it goes on to say, locations of new WCF facilities must, to the maximum extent feasible, co-locate on existing towers. And this is something I've already mentioned. There is, one tower that's certainly nearby, and structures or buildings. If they're not able to do that, then they have to provide you letters that state why they were not able to do that. And I'm sure they have done this. I'm sure they've done everything they were supposed to do, but we haven't really had time to review these things. An existing tower's height may be extended to, that was what I talked about a minute ago, to 10%. Then you get down here into, it says new WCFs, and this is if it were to be built, should be camouflaged and disguised or concealed whenever possible to make them compatible and blend into the setting and host structure or building. There's no way you're going to camouflage a cell tower to blend in with these residences around here. It just isn't going to happen. You can't make it look like a palm tree. As a matter of fact, once as you get down into these regulations, it says one of the things you can do is make it look like a tree, but it's got to look like a tree that's essentially native to that area. But that's kind of hard to do on a 125-foot structure. I also noticed in there where they had referred to this in their thing as a stealth tower. It's not a stealth tower. This is a monopod tower, which is also referred to as I think a stick tower or something like that, and something else. But where stealth does come in, that it is important, is when you get down to visual impact. It talks about certain things that have to be done. But on K, which is says stealth design technology, stealth design encouraged in all zoning districts, whether it's agriculture or residential. Stealth and concealment technologies must be appropriately given the proposed location, design, visual environment, so on and so forth, must screen all substantial portions of the facilities from view. Stealth and concealment techniques do not include incorporating faux tree designs of a kind that are not native to East Tennessee and out of scale with natural vegetation. There aren't any 125-foot areas right there. I mean,
I'm going to stop you right there for a moment. That's
Yes.
been 15. Unless the board has any opposition, I'd like to give you 5 more, which means the opposition would have an additional 5. But I want to stop you there for a moment so we can ask some questions, hear
All
from
right.
codes. So I'm going to have you stop for a minute.
I'll finish up very quickly. I didn't get into
Well, we're going
a
to
lot of-
stop for right now. I'm going to give you 5 more minutes, but not right this minute. We're going to go through some
okay.
questions first.
I'm
We'll
sorry.
have some questions, and I have a couple of questions for you, so don't sit yet.
Okay.
Steve, did you want to say something first?
No, I had nothing to add.
You had nothing to add? Okay, does anyone from codes or planning or anybody have anything to say to this point with what's been said?
Not at this time.
Okay. So I had, one of my questions was, you said that you knew that you needed to file an appeal 15 days from the approval. So I guess I'm trying to look at the timeline. So
Okay.
you had the 15 days, and when were you, I'm looking at dates. What date is that from? Someone tell me the date that's from.
I was told that it was from the day the building permit was approved.
There's some confusion here about the 15-day period is from the certificate of appropriateness, which was issued on January 27th of 2023.
Okay, and that's what I was looking at.
So there was 15 days from that date to appeal to Planning Commission.
Okay,
They have 30 days from the date of the issuance of the building permit to appeal it, our administrative decision to issue the permit,
okay.
which they met that 30-day window.
Okay, 15 days was not met per it being from January 27th, but they met the 30 days from the permit.
Yes, and it's two separate appeals. It's
Okay,
appeal-
gotcha.
They're appealing our decision to issue the building permit.
Okay, gotcha.
It never went before the planning commission, did it?
It did not, that's correct.
No.
It was an administrative review by
Right.
planning staff, and they issue the certificate of appropriateness to the cell tower company.
Yeah, my understanding was it did not have to go to planning.
It was in the code, there are two separate reviews. There's a level 1 review, which is done administratively, and then a level 2 review, which would go before the planning commission.
Okay. Mr. Huff, I think your light was on first.
Pull the mics down, way down.
Was it? Oh. We can't hear or we can't see.
Actually, you asked a couple of questions that I already had, but I'll ask you, the applicant, when did you find out that they were building the cell tower there? What was the time frame when you found out?
When we called, right? I mean, we had heard rumor about.
Please use the mic,
I'm
sir.
sorry. We had heard rumor that there was going to be a cell tower there, right? But it was always felt like it was in the dark. We weren't really sure. We saw stakes go in the ground, and then we eventually called every day to find out, oh, there was a building permit, whether it was issued or not. And go ahead.
When I started calling the permits department.
When was that? Do you remember?
Take a guess, a month?
Well, do you know when the permit was applied for? Not approved, but when it was actually applied for. Anyway, it
We'll
would
look
have
that
been
up.
approximately a month before the permit was actually applied for is when I started calling about it. And at that point in time, the county had no record of it whatsoever. So I could not confirm it or anything because the county, until the building permit was actually applied for, they had no knowledge that there was going to be a cell tower built there.
And we will second that. We're not aware, when they apply to planning, we're not made aware that cell towers are there. So, we have no idea until they
But
apply for the building
planning was
permit.
aware that it was a cell tower.
Yes, they apply at planning, not to our office for
But you
the
didn't
level
check
1.
planning.
How would we know?
No,
How
I'm
would
just
we
asking.
even know to do that?
No.
Yeah, we're,
You know?
No,
yeah,
we-
we're,
I'm
hold
just
on one
asking
second.
for information.
no, ma'am.
That's what we're trying to figure out.
Yeah.
No. Well, I will say this, when we found out, although this was before I found out, then they requested a meeting with the owner of the property to discuss what was happening there, what the procedures were, and to discuss possible options on the property.
Who asked for the meeting? Who asked for the meeting?
What was it? Tanya Hobbs and Walter. Yeah,
They're here?
they're here.
Yeah.
Ms. Garrett, were you finished with your questions? Okay. Mr. Huff, 1 second for me. I want to see if this is all flowing together. Hold on.
You mentioned, I think it might have been in the code.
Pull your mic down.
I think you mentioned, I think it might have been in the code about the requirements for cell towers to be stealth.
Yes, sir.
Steve, do you agree with that? I mean, are they required to be stealth?
I'm sorry, I'm having trouble hearing you.
Do cell towers, are they required to be stealth by the code?
Stealth.
Stealth.
That's, our review of the permit is that we get the certificate of appropriateness from planning, and then we review the structural aspect of the tower. We don't review that. I think I would defer to Lindsay to let her speak to the stealth.
Okay.
And, sir, if I did, then I misstated. It's encouraged it's not required to have stealth design technology. It's encouraged in all of them. If you look at number 3, it says a criteria for new towers within 2,000 feet of this, that, and the other. Well, that's something else. Anyway, zoning districts permitted tower. The only one permitted in this particular application is a small cell or a monopole type one, which is another question I would have. Was a study ever done as to whether a small cell tower, which is limited to, I think, 30 feet, would have been sufficient here? I know you can put multiple towers, but anyway, regardless of that. And then stealth design in all of these is encouraged. And then it goes on to talk about, as he was referring to, either a level 1 or a level 2 review.
I'm sorry, I forgot your name already.
Rick, I'm sorry.
My name's Lindsay
Oh.
Crockett. I'm a staff planner with Knoxville, Knox County Planning, and I reviewed this case.
Okay, I have a question for you then. Is there anything in your guidance that explains what stealth is for
Yes.
these cell towers?
So stealth design, I will echo the applicant here in saying that stealth is encouraged in all zoning districts, but not required. So stealth are concealment techniques that must be appropriate given the location, design, visual environment, and nearby uses, structures, and natural features. So it says included but not limiting to clock towers, flagpoles, or faux trees. The code says that stealth design has to be constructed to conform to surrounding building designs or natural settings so that it's visually unobtrusive. And the intent is to reduce visual impact to screen substantial portions of the facility from view.
Based on your understanding of what you just read, does this installation meet the requirement, the suggestions that it be stealth?
No, the tower itself does not incorporate a stealth design or technology.
Okay.
There are landscaping and screening standards that are another section of the code that are required, and it does meet the landscaping standards, but it does not incorporate a stealth design.
So do you find the fact that they label it as a stealth tower to be accurate, correct, or incorrect?
Do you see that on the plans somewhere?
It's on the plan.
Yeah. There's the plan.
Could you let us know which page you're referencing, Mr. Huff, so we can all look at it?
Yes.
Here.
You can look at sheet number L1. That would be the landscaping plan.
Got it, yes. I concur that stealth
That's
wouldn't apply in that
incorrect?
instance. Yes.
Okay. I have an additional question for the applicant. Let me find the drawing. On drawing C-1.1, it says there's an existing H-frame with a meter bank. The pictures I see of this site, there's no electrical cabinet there.
No.
Is there an existing electrical cabinet that's there now since these pictures were taken?
That says proposed AT&T meter existing, and I'm sorry, I can't read that for sure, something frame
No, right.
with meter bank. I have no idea, unless that's underground or something. I mean, it's not in any of the pictures that are.
I'm not an electrician, but I'm pretty sure that's would not be underground.
Yeah,
Okay, so that's another incorrect statement on the plans?
Sir, I cannot, I drive by there 10 times a day, and I don't know that I have ever seen that. The owner could speak to it, I guess, but I don't know of anything there right now, no.
Lindsay, do you know if there's an existing H-frame meter bank?
I do not. We could possibly see
you
it
ever
on
seen
Google
anything
Street
like
View.
that? Hey, where are your shots?
I realize this may sound pedantic, but these things are important. I mean,
They are important. Can I approach you or anything with this?
you can come see
It's-
me. I have no problem.
Yes. We won't knock you back. What are you trying to show? Show us all. Yeah, let's see. Okay.
Yeah, we have a picture.
Do we have that? On what page are you referencing? We can all look, yes. Okay. Okay.
This. Is that it?
What's he saying is existing?
Okay, we do
So
have
maybe
it in
it's
our
just not,
packet.
yeah, we have that page in our packet. Yes. Well, is it something maybe we'll have to ask the opposition
there.
first on that to see if it's
That's
just not
it.
built yet, so it could very well be not built yet. I'd like to ask, if the board has any other questions, I just want to ask, before we go to opposition. I kind of want to get a better timeline from you, if I can. So I've heard you talk, and I know it's a little redundant, but I just want to make sure. Because in this situation, my understanding is you didn't have to have any notification.
Correct.
You called, you inquired, you tried to get the information you could get to stay within your days the best you could for appeal. It sounded like you did hit the within 30-day appeal, but not within the 15 days. Am I right so far?
Yes, ma'am.
Okay. So what I'd like for you to take me back to a little bit and try to remember the best you can are the times you heard there may be a cell tower. When did you hear that? When did you call? Did you talk to planning? To be able to say, is there a cell tower going there? Do you have an application for anything like that? So if you could give me some timelines, that would be helpful, the best you
Well,
can.
what would be real helpful is if we could actually verify when the permit was applied for. And the reason being is because I started about a month before that in calling the planning department and to inquire of it, and they had no knowledge of it whatsoever. In fact, they would ask me what the address was, which I gave them, and at that point in time, the address was for that whole piece of property. This piece of property actually includes a house and a barn,
Right.
sheds on it. It has now got two addresses instead of one address. So the address that I was giving them was actually the only one we knew about, which was for the house. So it would have been an incorrect address, but that doesn't matter because when it finally did get applied for, they obviously were aware of it at that point in time. So until that until the day that it was actually applied for, we had no confirmation that a cell tower was going onto that property. We had rumor, but at that point, as far as we know, there were stakes in the property. They had been staked a couple of different times. The property grows up, gets mowed,
And who did you call? Did you call planning to ask this question?
I talked to Kim Jarnigan, yes,
Okay, so Kim Coates, okay.
Codes.
on
Coates.
numerous occasions. She was extremely helpful.
Okay, so do we know when that date is? Steve, are you looking at that?
The permit was applied for on May 8th, 2023, and issued on June 21st, 2023. And the certificate of appropriateness was issued on 1/27 by planning.
And the
So that's-
certificate of appropriateness was applied for December 22nd, 2022.
And that's where the 15 days should have been, the appeal should have been made on that within the 15 days, correct?
To planning commission off of that 127.
But it wasn't, I guess I got a couple of things there. One of them, it never went before planning commission. And B, the zoning department nor the permits department were aware that it was even in the works.
So so my question again on timing would have been, you started reaching out to codes, it
If-
sounds
if-
like after
In
the.
February.
In January you did.
Well, I mean, if the permit was applied for in May.
December. I'm sorry, I'm talking about the planning. The planning certificate approval date is 1/27/23.
Right, which we knew nothing about any of that.
At that point, you knew nothing. That's what I wanted to know, all of that. Okay.
Yeah.
I think if the board doesn't have any other questions for the applicant or codes or planning or anybody, we'll let the opposition have their 15
Can I
minutes.
make one more statement very quickly?
Very
Because
quick.
it's part of the 4.9.2. And this goes down into what the
All right,
planning commission.
I'm gonna give you that on your 5 minutes because we're gonna finish with our questions first and then you can come back on the 5 minutes. I'm gonna give you 5 minutes, but
Okay.
let me get to opposition and let them have their time first,
All right.
okay? And then we'll give you some more time. We gotta take it all in.
Thank you.
Okay?
Madam Chair,
Yes.
could we ask, Mr. Huff, what sheet was that on where it said existing power banks? Ours are, I'm
It's on the
only seeing
plan.
proposed.
Yeah.
Right here.
What sheet?
This plan sheet is sheet
Would you use your mic, please, Mr. Huff?
Sorry. It's on the plan sheets, and it's plan sheet number C-1.1.
Yeah.
Exactly.
The approved plans, I don't know, the approved plans on ours say proposed, so I don't know how that's.
I think it is proposed, yeah, that's what I was
it's-
looking at
the-
as
the-
well.
The plans we have in our file say proposed.
That's what I wouldn't think it would be there yet. You know, and we do want to make a note because it was brought up by somebody that the address
Yeah, those aren't approved.
was different, and I think the applicant said that. And I found that too when I was driving to the property, that the addresses were different, so it made it a little bit difficult to kind of know where I was for a minute. I figured it out from the photos, but I had all the information in front of me, so.
Well, this is
Right.
the drawing that's attached to the
Yes.
certificate of appropriateness.
Yes,
This says
yep, we got that.
that it's there, yeah.
Yep. All right, so if the opposition would like to come down, if the board has nothing else for the applicant at this time? No? Okay, if the opposition would like to come down, state your name and address for the record. And you again will have 15 minutes and then an additional 5. While the opposition is getting ready, Steve, would there have been any, well, they were calling, if someone was calling planning or codes and asking for one address, you're plugging it in your computer, would the address difference have made any difference whatsoever on an inquiry as to what was going on with the property?
It wouldn't, because what we would do is pull up our cartograph, and it would show, 2 separate permits on that parcel. It would give us a dot and show there's permits there. And what happened with the address is that parcel was addressed as one address. This cell tower would require a separate address, so when they applied for the building permit, they got a second address at application time. So it only had one address up until the building permit was applied for.
Okay. Okay, if you would please give your name and address for the record.
For the record, my name's Robert Grant. I'm an attorney for AT&T Mobility. I have with me Glenn Katz, who is an expert in real estate valuation. And I just lost my picture.
Use your mic for us really well. It's so hard to hear up here as well.
I just lost my picture.
Codes, what address should we have on our files for the clerk?
Oh, that's his case. Oh, you pulled yours out of there.
You're trying to.
She turned my computer off.
I apologize.
I'd like to
we started
begin with some responses to Mr. Denton's comments.
Did you state your name and address? I think you did.
Robert Grant, attorney for AT&T Mobility, and it's 1578 Highway 44, Shepherdsville, Kentucky.
Thank you.
As you recall, when the planner was reading the definition, when Leslie was reading the definition of a stealth facility, it included a flagpole. This is the flagpole that we're proposing. So this design does meet the definition of code for a stealth facility. What it is all the antennas are on the inside of the pole, as opposed to what you typically see with what we call a cheese head, with all the antennas protruding out on a horizontal level. So this is the stealth monopole flagpole that we're proposing. Secondly, let's see, co-location, we did speak with these folks at 3001 Sam Lee Road, and attempted to co-locate on their tower, but they weren't willing to lease a space, so we had to look for a new raw land space on this one. I'd like to go back to the beginning here. And, well, one other point I'd like to address. Mr. Denton says that their first indication that there was going to be a cell tower was when the property was staked out. That happens a month or two before we file our zoning application. In this instance, we filed our zoning application in December of 2022. So our surveyors would have gone out and staked out the property, done core samples for a geotechnical study, and done some preliminary work at that time. So that would be, as I understand his testimony, when they first had some indication that there was going to be a tower on this facility. So they started calling the planning department. We had not made our application yet. And in the fall of 2022, that application was made in December of 2022. And as you know, it was approved in January. So the critical appeal date to object to the location and appropriateness of this facility was early February. It would have been 15 days from January 27th when the Planning Commission staff made their determination that upon their review of the zoning ordinance, this application that we were making met all the requirements of your zoning code. Let me repeat that. This site, this location, and what we're proposing meets each and every requirement of your zoning ordinance. And it's necessary in this area by Mr. Denton's own comments. So, you know, what this is and what we're proposing is essential public utility infrastructure. Here's the state of Tennessee recognizes that this is essential public utility infrastructure. They've stated that Tennessee's economy depends upon the ability to utilize robust mobile connectivity. This is how we communicate with each other in this day and age, folks. As we all know, landlines are disappearing. Our mobile devices, our smartphones, are how we communicate. And it's how we communicate not just by voice, but it's how we communicate by text messaging. It's how we do our banking in many instances. We make those purchases from Amazon. We watch a Netflix video. We get on our social media and watch a cat video, for heaven's sakes. But it's how we connect with the world right now. And all of that data gobbles up a monumental amount of bandwidth. And because of the amount of bandwidth of all that data, all those transactions going through your mobile device, for it to work the way it's supposed to work, we have to have cell sites. Now, when we do that, we do our very best to put a cell site in. First of all, we do our very best to co-locate. The one tower nearly a mile away was not available to us. They turned us down. And so that left us with looking for a cell site. And what we went to is we went to an agricultural zone where towers are a permitted use, as Mr. Denton acknowledges, and as your code very clearly states. So we located a tower where it's appropriate under your zoning regulations. We designed it with stealth technology as per your zoning regulations recommendation, okay? We met each and every criteria in the zoning ordinance as your staff poured over it and issued the certificate of appropriateness. And then your building inspector reviewed and signed a permit. So, you know, All your professional staff has reviewed this and made a determination that what I'm telling you is true and accurate, that this facility meets all the requirements of your zoning ordinance. In addition to that, the state of Tennessee recognizes that this is critical infrastructure for law enforcement, for first responders. This cell site will be installed with FirstNet technology. What that is designated line. This came out of 9/11. It's a designated line for first responders so that in the state of an emergency, those emergency calls can be made. Over 70% of all E911 calls are now made wirelessly. So this is a matter not just of convenience, so that you can talk to your loved ones and do those bank purchases. It's a matter of public safety, that you have a robust network for your communication services. Now, the way this technology works is that we have to be in an area to serve an area, because a cell phone is a fancy walkie-talkie. And we know that walkie-talkies are limited in their range. The way the technology works is the phone sends a signal to the tower, which sends it to another tower, another tower, another tower, and now you're calling your loved ones in California just like that. But for it to work in a community, in an area, to serve all of these people in their neighborhood, we have to have a facility in the neighborhood. Sending it somewhere else in Knox County will provide service to somebody else, not to these people. Your zoning ordinance also recognizes that this is essential public utility infrastructure. It recognizes the need to accommodate the growing demand for wireless communication services. Mobile data has increased by 53.4 trillion megabytes. That's all of that data flowing through the system that I was talking about. That is a huge load of data moving through the air, moving through the network of these sites. And your ordinance recognizes that it's necessary to meet these growing demands. And that's what we're doing here. Your ordinance also recognizes that one of the objectives of your zoning ordinance of this community is to furnish comprehensive and efficient services to the community, to encourage the latest technologies. This site will incorporate latest technologies, and to establish clear permit process. That's an objective of your zoning ordinance, to establish a clear permit process. We filed a zoning application in December that meets all the technical requirements of your ordinance, each and every one. Your planning staff reviewed it, agreed that it did, issued a certificate of appropriateness, and now 15 days. There's 15 days from that January 27th to appeal. We've already established that the neighborhood knew and heard rumors that all of this was going on when we were out staking. Aside from all of that, the ordinance, your ordinance gave them 15 days to challenge the appropriateness of this facility, to come up here and say the things that they said today. Today's not the day to do that. That time has expired. It's over. It ended in early February. Here's some numbers. Promote public health, safety, and welfare. 70% 911 calls are placed by wireless phones. 81.9% of the children live in homes that only have wireless phones. This is FirstNet. I mentioned that already. Designated line for public safety, so your first responders can get where they need to be. Planning Commission approved this on January 23rd, according to our records. No appeal was taken within 15 days as required by Section 492 of your ordinance. Since no timely appeal was made of the appropriateness of the tower at this location as a matter of law, this board cannot hear evidence regarding the appropriateness of the tower's location. That time has already passed. We've submitted a legal memorandum to your legal counsel on July 20th and to your building inspector, outlines all of this, outlines the law that we're talking about today, and there's a copy of this memorandum in your binder that I handed out to you. This appeal lacks merit. It was taken from the issuance of a building permit. If anything, they ought to be looking at whether a building permit was appropriate, but let's talk about that for a second. Section 6.505C of your zoning ordinance provides that a building permit shall be issued, subject to all conditions and requirements stipulated by the Planning Commission. That's a certificate of appropriateness issued in January. That's what your building inspector's done here. He complied with your ordinance. He complied with the law. And what did the courts in Tennessee say about this? The issuance of a building permit is an administrative or ministerial act. The building inspector must follow literally the provisions of the ordinance. And he's done that. Your planning staff must follow the provisions of the ordinance. You must follow the provisions of the ordinance. We did. We worked really hard to locate this site to meet each and every requirement of your ordinance. We did that. The time to raise an appeal was in February 2023. It's passed. This appeal is not timely and it lacks merit. There's some federal telecommunications law that applies to this. This is one of the rare situations in zoning law where the federal government has a huge say in what you do, what local government does. And what the courts in the Sixth Circuit, which controls what happens here in this community, what happens in Tennessee, has stated very clearly that any denial of a permit or an application must be based on substantial evidence. And substantial evidence is, what does your zoning ordinance say? Did we comply with the zoning ordinance? Did we require any variances or waivers? No, we did not. We complied fully. If you look through it, it's case after case after case. Substantial evidence is compliance with the zoning ordinance. This cell site complies with the ordinance. Your planning staff has confirmed that. Your building inspector has confirmed that. Each and every requirement in the zoning ordinance. Mr. Ditton had some very vague comments about the ordinance, but your professional staff ticked through it item by item by item. Check mark, check mark, check mark. Complied, 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 and approved it and issued a certificate of appropriateness in January.
Okay,
Yes, ma'am.
that's 15 minutes there. That ended on a good end of a sentence, I suppose. So if you'll stand there, we probably have some questions. So Ms. Garrett, are you on? Okay, go ahead.
You stated you had made every effort and worked really hard on meeting all of the requirements. As a courtesy, did you make any attempt to reach out to the community at all? And if you did not, why not?
We did reach out to the community. We reached out to the representatives of your community, your planning staff, because it's your planning staff who represents this community. It's your planning staff who we interface, not just in this community, but in communities all across America. That's the way it's set up. That's what your zoning ordinance is intended to do. And that's what this lady's job is right here. Her job is to be a representative of the community. And when the planning commission and your county commissioners or county or city, you know, when a zoning ordinance is enacted, all of those requirements are discussed and all of those criteria are established as the baseline of the community values, what this community wants to happen for a cell tower. That's to give us a roadmap. All those federal cases are all about situations where a community departed from its roadmap, departed from its regulations, and decided that, no, you need to do something different. So yes, we communicated with the representative of your community. No, we did not have a neighborhood meeting. We did not do that. Now, in some instances, that would have meant a planning commission meeting, a public hearing with notice to the neighbors. But your ordinance designates this as a level 1 administrative review. If we meet all those criteria, that's the review process. The community has already made a decision when the ordinance was enacted. That was the will of the community, and we complied with the will of the community.
Mr. Huff?
You say this is going to be a flagpole?
Yes, sir.
Whose flag?
It will be an American flag, sir. I started to make a joke, but that would have been inappropriate.
Thank you. Steve, are there lighting requirements for flags if they're going to be left out overnight?
None that I'm aware of. I don't.
No?
None that I'm aware of.
Okay.
There's nothing in our ordinance that would require a flag to be lighted.
Okay.
And this tower will not require lighting under FAA requirements. There won't be any lights on it.
Was the use of well, let me do this first. Is there someone here from either Mass Tech or someone else who can speak to the current revisions of your drawings?
No, I do not have an engineer here with me today.
And perhaps you'll know. What is the current revision level of drawing C1, C-1? Is it Rev 0, Rev 1, Rev what? Because apparently, at least one of the drawings has been revised since this package was put together. It'll be in the upper right corner of the drawing.
Just a second, I'm pulling the drawings up.
Are these drawings in our packet, Mr. Huff?
They are in the packet. I'm just trying to determine whether we have the most
Yep,
current
there we go.
drawing.
I just wondered which one he was talking about.
C1, C-1.
Here are the drawings. I don't know if we can see them, but
Again, I apologize to the board members in the audience. There is a purpose for this.
The plans that we approved that have our stamp on them have no revisions to that sheet.
They're all Rev 0.
For that C 1.1, yes.
Okay, what about, C 1.1, what about C-1? That's perhaps the more important thing. What did you approve?
It has no revisions either.
It's all Rev 0,
Yeah.
L1's Rev 0,
L1,
C2 is 0?
that's correct.
Okay. Turning your attention, Counselor, to drawing C2.
yes, sir.
You mentioned in your earlier statement that the antennas would be inside the flagpole. That is not correct according to this drawing. They will be on a canister mounted with stainless steel or with steel binding, not inside. They'll be on top of the pole at the top of the 124-foot elevation. So I'm trying to get a picture here of what the planning commission saw, what they thought they were going to put in, and what's actually going to be built.
Yes, that canister they're showing to the left goes down inside the tower. So that all goes together, then it fits down inside the tower shell itself.
Okay, what is that thing sticking up above the tower in the
That's a lightning arrestor.
lightning arrestor?
Yeah, that's, if you look, Kelly, or zoom over. To the left of that detail, you'll see the canister showing you like an elevation looking down, and you'll see the antennas inside the canister. Keep going left on your screen. Oh, you may not.
Since I can't tell where that section's cut, Steve, there's no way I know where that is.
Yeah, it's. If we can hook mine up, I can show you the detail.
I think to Mr. Huff's point, he's just making sure that what everyone has approved is that, and nothing's been,
Yeah,
there's no revisions, there's no changes.
I think by definition in our ordinance, this is a monopole, and I think they're calling it a stealth monopole, but by definition, it is a monopole in our ordinance.
Okay. Are you sub-metering power for this, or is it coming straight from the utility, whoever that is?
I don't know. I would answer that if I knew it, but I don't know.
Your lease agreement with the property owner says that they have the responsibility for maintaining your landscaping. How do we know that's going to happen?
We have them here.
I would assume the codes department as well would be contacted if there's an issue.
Yes, it can be, clearly there can be inspections, but,
Speaking to the mic for us so we can hear you, sorry.
yes.
That landscaping requirement is something my staff enforces, and it's
Okay.
complaint generated. Someone complains the landscaping is not adequate or didn't survive. We would send staff out to inspect and issue a notice of violation if it in fact wasn't there.
And that would go to the property owner or to the lessee or lessor? I don't know which one it is.
Property owner.
And the property owner would notify us immediately.
And if they did not address any issues, then you would take care of it and they would be invoiced, I'm assuming?
Yes, we would, our standard procedure would be we'd issue a citation to court. The property owner would go to court. We would get some sort of fine, court costs. Then if they didn't comply, we'd turn them over to Mr. Moyers, who would get injunctive relief against them and would really give us the leverage we needed to have the landscaping installed.
Okay.
But once you find out whether you're going to be direct metering or sub-metering the power for this, can you confirm that it's going to be underground or overhead?
I can confirm it with your building inspector, planning staff. Yes, sir, I can do that.
Okay.
Mr. Lloyd?
Yes, couple of questions. You said something about a flag on the flagpole. Is there in fact going to be a flag?
Yes, sir.
Who's going to maintain it?
I don't know the answer to that. Typically, we maintain our facilities. It's our responsibility to do that. There was some mention of traffic. This is an unmanned facility. About every 6 months, we have a guy come out in a pickup truck to inspect the site, to inspect the landscaping, to make sure everything is in good working order. The flag would be inspected at that time. And that's just kind of on an average, so a couple of times a year. So virtually no traffic impact. And we do inspect and take care of our equipment. I mean, this is a critical component of our network, our communications network. So yes, we inspect it, keep an eye on it, make sure everything's okay.
One more thing, it looks like on C1.1 that you expect to probably have 2 future carriers on that location. Is that true?
We've designed it for a minimum of 2 additional carriers. We do that because your ordinance requires it, and we also do it because we do it with all of our facilities. We have agreements with all the other carriers and to co-locate on each other's equipment. We co-locate as much as possible. In fact, I would say more than 50% of our facilities, new facilities, are co-locations. Whenever we can do that, we do it. And we make ours available to other carriers.
So there's a possibility of 2 more transmitter buildings and 2 more 30 kW generators on that site?
Yes, sir. I mean, you know, that's how the technology works. And the antennas in this instance are canisters inside the tower, but on the ground, we have a cabinet with all the expensive, fancy schmancy, I call it fancy schmancy electronic equipment because I'm a lawyer, not an engineer. But that's on the ground, and then there's cabling running up to the antennas. But yes, if someone co-locates, their equipment will be set on the ground. And of course, the landscaping, you know, the landscaping is not going to hide a 120-foot tower. What it hides is all the ground equipment. You know, that's what it does.
Would there be,
It makes that more green.
I'm sorry, I was going to ask codes, would there be new applications required for anyone that wanted to come on the property?
Yes.
And then at that point, would someone have 15 days to appeal an additional or no?
I believe co-locations are just reviewed by our department once the tower's there. And going back to Mr. Huff, I did verify in the plans, the power and the fiber to the facilities will be underground coming. There's an existing power pole at the driveway, and it says it'll be underground back to that power bank.
It'll be coming down that utility easement?
Yeah,
Okay.
yes, that's correct.
I'm sorry, Mr. Lloyd, I didn't mean to interrupt you.
I just didn't know if codes had actually looked at the future carriers. 3 generators on that site would be quite an industrial application.
Well, the generators are for emergency purposes only. That's in case the power goes out. Every once in a while, I think they turn on briefly for a test run. They're all designed to muffle the sound for the surrounding community, but they're not running continuously. They only run in an emergency. And if there's any sort of an emergency where the power goes out, everybody's attention is on whatever storm emergency or whatever's occurred that, you know, that would require, that caused the power to go out.
Ms. Longmire?
I have 2 questions. One is for the clerk. What address should be on this application? Is it the 11445 or 11425? Codes needs to tell us, yeah. She needs that information.
What's the address? 11445 is the new address for the cell tower.
Okay. That's just what we needed. And my other question is for our attorney. The reasons that are given for this appeal doesn't have anything to do with 15 days. What are we actually looking at in this appeal that we have power to do something about?
Okay. All right. This is where the situation, from the point of view of the community, I think is understandably difficult, because I think Mr. Grant is right in what he has stated about the timing. Under our code, there are 2 levels of review that are required in certain circumstances. Certain types of towers in certain zones require planning commission approval at a public meeting of the planning commission. Other kinds of reviews are simply administrative reviews by the planning staff. Under section 4.92G, it talks about the procedures for the level 1 review and says that a determination shall be decided, and this is determination by the planning staff, shall be decided within 45 days of the complete application, and the applicant shall be provided with a written notice of approval or denial. If approved, the applicant will be issued a WCF COA, or Certificate of Appropriateness. Anyone aggrieved by an approval or denial shall have 15 calendar days to appeal the decision to the Planning Commission. Now, the COA, the Certificate of Appropriateness, is where it was determined whether the zone was appropriate, whether the proposed tower met all the requirements of the Knox County zoning ordinance. That was done on what day? Steve?
127.
January 27th. Under our code, anyone aggrieved had 15 days from January 27th to appeal that decision to the Planning Commission. Now, I understand the problem. You didn't know. And that is a weakness of our zoning code. It does not provide that any notice be given to the community. And so Mr. Grant and his clients acted within the law. They weren't under no legal requirement to reach out to the community and say, this is what we're going to do. And there's no requirement for the Planning Commission to have noticed or notified the community that this was under review. This is something that I've discovered in the last day or two. I have spoken to Amy Brooks, the director of the Planning Commission, and administratively, she's going to start noticing these things. When they're applied for or when they're approved, we're going to start putting signs up as we would a use on review so that communities will have that knowledge. And I'm fairly certain that we may see some changes to this ordinance. I don't know this for a fact, but I'm told that prior to a 2022 amendment to our code, all of these went before Planning Commission. Is that true? I don't know if that's the case. I haven't looked at the ordinances, but...
I believe prior to 2017, they did.
17, okay. So, you know, the county commission has within its purview the ability to say that all of these in any zone should be required to have planning commission approval at a public meeting. That is a way we could go. But unfortunately, for the purposes of today, the requirement was that somebody, if anybody was aggrieved, if anybody doesn't like the fact that a COA was issued, they had 15 days from January 27th of 2023 to have appealed it to the Planning Commission, and that was not done. The Board of Zoning Appeals has limited authority. It has authority to review the actions of administrative officials like the building inspector. There is Tennessee case law. I've got one case, and there are more, that says that the Planning Commission is not an administrative official for the purposes of the authority of the Board of Zoning Appeals to review. So the BZA does not have the authority to overturn acts of the Planning Commission. And even if it kind of normally did, the fact that our ordinance says that an appeal had to go to the Planning Commission and not to BZA kind of pretermits that anyway by the language of our own zoning ordinance. So to prevent something like this in the future, we're going to have to look at this ordinance and amend it and at least either provide notice or provide that more of these matters go to the Planning Commission or something that will give communities assurance that they have a voice in this. But currently, that voice is limited. I'm just sorry to say, it just is. And that's been the case apparently for some years now. Because of all of that, the only thing that this body is empowered to do is to review whether or not it was appropriate for the building permit to be issued. And what I've heard Mr. Elliott say is that once the COA was issued and once a bond was obtained from the tower company, he had no discretion. He was required to issue a building permit. And so unless this board finds that the COA was not issued, not whether it was properly issued, but was not issued, or finds that Mr. Elliott did not get a bond, I don't know what authority this board would have to intervene in this process at this point. I know that there are preferred and less preferred areas under our code for the location of these, but this is located in an ag zone, and under what is this section? It's 4.92C sub 3. If a new towers are an option of last resort. The most preferred situation is the co-location, but Mr. Grant has told us that that was not possible here. I am a bit curious, if you let me ask you a question. You said that you had agreements with all the other carriers about co-location, so why were you turned down for the one that was 3,000 feet away?
I don't know. I think I wasn't involved in the process. I didn't have conversations with them. I don't know the answer to that. Sometimes that occurs because the tower's fully loaded and there's no space, and the tower isn't structurally sufficient, or there's not ground space. There's some physical impediment.
Okay.
Because
let me just direct it to the lady from Codes, and I'm sorry, I've forgotten your name. But did their application explain why co-location was not possible?
Hold the mic down so we can hear you too. Yeah.
Yes, so the they have a section in the application where they define their search area, which has a center point and a radius that's identified by the carrier. They say the site development team first reviewed the area within the search area for a suitable tall structure for co-location. There are no existing FCC registered towers in the search area. So the application cites that this search ring that they defined, that the ATT or whoever it is defines, did not have an FCC registered tower in that search area. They also said there are no other existing tall structures suitable for co-location at the height required to address the service need in the area. The only registered tower within 1 mile of the proposed site, they list that specific tower's registration number and say it's outside of the search area, so antennas placed on this tower will not reserve the service need in that area. Further, it's unavailable for co-location because the landowner of the site parcel is unwilling to allow additional co-locators at this time.
And so that may be an issue with the actual lessor of the property and not the carrier, I suppose.
Well, it's a double issue, because our engineers issue this search area. The way the technology works, if we get too close to an existing site, then they interfere with each other. If we're too far away from existing sites.
And I assume you mean an existing site for your service.
For our service, then we have gaps in service. So that's what the search area is about. That's what our engineers say. Our engineers say, find me a place in here. And that tower is almost a half a mile outside of where it needs to be. So even if the landowner would have been willing to expand the space and let us go on the tower, it would not have met all of our needs. So this community would have still had some service issues that we couldn't resolve by going on that tower. The science of it.
So if co-location is not feasible, then there is a list of preferred sites to place them. And the applicant pointed that out: industrial and business park, commercial and office zones, other zones. And I don't know all the reasons why they couldn't locate in some other place, but the Planning Commission, or the Planning Commission staff, reviewed this, and when that was not appealed to Planning Commission, that was kind of the end of it. So the bottom line is, we need to work on our ordinance. Like I said, administratively, I think Ms. Brooks is going to start making sure that the public does get notice of these when they're applied for. But I know that's cold comfort. I do. But I've told you the grounds that you can address, and unfortunately for the community, the issues that they have raised in their appeal should have been raised, must have been raised in an appeal of the COA. They are not properly before this body. The only thing that properly could be before this body is the question of whether or not it was correct for Mr. Elliott to have issued the building permit. And as I understand it, the only requirements that he had to have in order for him to be mandated to issue that permit were an issued COA from planning and a bond from the tower company. So if you have any other questions, I'll try to answer.
Okay, well, I know, if you'd had your 15 days, if you knew within that 15-day period you made your appeal, there was obviously no 100% guarantee you would have, received what you wanted. We don't know that. What I know I can do right now is I told you I was giving you another 5 minutes, and I'm going to. So I'm going to have the applicant come back up. You've got 5 minutes to say what you want to say. I will say one other thing. I was a little disappointed in that I know the code staff will put signs for our notices of variance. And I do know that one of our board members had driven by and saw that sign. And I know when I was out there, the sign was not there. So I think that was kind of
It's actually been taken down multiple, it's not even
Yeah.
up now.
Yeah, so I think that's kind of in poor taste that sign was taken down. So those are notices for the public to see things and to know and to be aware and to see, know what's going on. So that's a little disappointing that those signs were removed for whoever did it. So
I appreciate
you've
that.
got 5 minutes.
We called, and the third time we called, they said that they had posted it twice and they weren't coming back out there and post it again. Anyway, very quickly, the gentleman that was just up here, yeah, I don't know what that search area is, but it must be awfully small if it didn't include the U.S. Cellular Tower. But anyway, and the other thing, the big thing here is, to me, is that there was no public notice of zoning application hearing. We had no way whatsoever to find out about this. What the gentleman says about, well, it had stakes in the property, therefore we should have known a cell tower was going up. I've been building and designing in Knox County and Knoxville City since 1977. I see stakes on properties all the time. I see core sampling, and generally it has to do with the building that's going up, so there was no concern about that. We had zero indication there was a cell tower going up other than rumors, and we were didn't verify this until the building permit was actually applied for. This whole article right here, very quickly, 4.92 is why this cell tower should not be being built here. And the end of this article is what I would like for this board to look at here. It says, independent review. The Planning Commission may retain the services of an independent qualified radio frequency technical expert of its choice to provide technical evaluation of permit application for WCFs, including administrative public hearing review. The technical expert review may include, but is not limited to, the accuracy and completeness of the items submitted, which we've already seen the other issues there, submitted with the application, the ability of analysis and techniques and methodologies proposed by the applicant, the validity of conclusions reached by the applicant, whether the proposed WCF complies with the applicable approval criteria set forth in this chapter. I do think that this board has the power and authority to require that that be done by the Planning Commission. Thank you very much.
I just would like to speak to this as someone who not only lives in that neighborhood, but I, about a year ago, bought a piece of property 175 feet away from it that currently has a little mobile home on it. And my plan was someday in the future to build a nice house, which would increase the tax basis. But if it's going to sit in the shadow of a 120-foot cell tower, it wouldn't be worth building a house on because it's going to affect the value. There are plenty of studies, we included them, that show that this will hurt the values because it's not in character with the community, which I'm really not sure how this made it through even the Planning Commission, because Article 4, 10, 16 states the use is compatible with the character of the neighborhood where it is proposed and with the size and location of the buildings in the vicinity. This is in the middle of a field. There are no trees to back it up against to make it kind of camouflage. I don't know how they even approved it, to be honest. And if we had known, we would have appealed it then, but we had, like we said, we had no way of knowing. So anyway, thank you for your time.
You still have a minute and a half.
Okay. Good day. My name is Susan Lynch, and my husband is David Lynch. And I wrote this email, but I wanted to read it to you today. I would like to voice our deep concern for the potential construction of a cell tower at 11445 Sam Lee Road on the corner of Sam Lee Road and Couch Mill in the Hardin Valley area of Knoxville. We respectfully request the board not allow this cell tower to be constructed at this location for several reasons, including the following. If you look on the sign, we are directly, that big house, we're in Chadwick Downs, we are directly across from the cell tower. This site has absolutely no trees and is just in an open field very close to a busy corner on a narrow road. It will look hideous and will not blend in at all aesthetically. It will stick out like a sore thumb. I'm actually dumbfounded to think there's actually a plan to put one here. I can see no other reason but profit with no consideration for the neighbors and neighborhood. There are other cell towers in Hardin Valley well placed on hilltops surrounded by dense forestry. Hardin Valley is a beautiful area and we cannot afford to be careless in our approach to development. This site is directly across Sam Lee Road from our property line. The soil testing was approximately 75 feet from our property line and approximately 225 feet from our house. I do not feel safe being near such a tower. And additionally, I watch grandchildren 2 days a week in the summer, and I do not want them exposed to this tower. The evidence is not 100%. There are no health risks. One site I saw recommends at least a quarter of a mile from a tower for health safety. The local property owner allowing this tower construction does not live on site. This is rental property. This cell tower will deter from the enjoyment of our property and surrounding and well-being. Where once we saw horses grazing from our backyard, now will be on full display a 124-foot behemoth of a cell tower. How can this be? Our property value, as well as others nearby, will decrease. Potential buyers will also diminish. Additionally, this is an established residential area. My husband David has lived in this house in Hardin Valley for over 30 years. I am beginning to call Hardin Valley Metro. We have had tremendous development in the last few years, and it just keeps continuing, and it's a bit overwhelming. Our country living is being swallowed up bit by bit. There is a 200-acre housing development under site preparation directly behind our property at present. That future development of hundreds of homes is catty-corner from this planned tower. The traffic continues to multiply on these narrow country roads. Even this month, an accident happened on this very corner of Sam Lee and Couch Mill Road. This cell tower will not enhance visibility. Please note, which we saw, the variance sign to announce this zoning appeals meeting was removed, and so we mentioned that. Lastly, please consider our request to not allow this cell tower to be constructed at this location. We appreciate consideration and attention to this matter. Thank you very much. Respectfully, David and Susan Lynch.
Thank you.
I did
That's
not know
time.
anything till a paper came out and the variance sign came up. I did not know about this ludicrous appeal process. I thought we'd have a sign out there for Shirley. Bless Mr. Denton's heart for seeing a stake. What kind of shenanigans is that for a community to have to be on an investigation? So I feel like, please consider it. I don't know who will take this up to next, but I'm going to keep going with this. And I'm sure your hands are locked. I know you fully order it. But thank you so much. Please consider that. Thank you.
Thank you. Opposition, you have Tom as well. The same amount of time if you would like to say anything else.
No, ma'am.
Okay, thank you. Mr. Huff, Ms. Garrett, both your lights are on?
I just had a couple of questions. One for the applicants. If you'd been notified at all, would you have made the appeal within that 15-day window?
Absolutely, absolutely.
But you were not notified, so you don't know what you don't know.
We jumped just at the, like I say, we called every day, almost, not every day, but most every day. Once we found out what the process was and what it had to be, just to come before you, we called the planning department every day almost to find out, to make sure we had our application to come before you. We would definitely have taken every advantage of an appeal to the planning commission.
Yes, and I would have too.
Mr. Moyers, obviously you were saying we have no authority to disagree with what the administrative approval of the proposed site. Is that correct?
That is correct.
Is there any other recourse that these community members have to after this?
You know, there's no administrative procedure left to them that I'm aware of. So they might have recourse to the courts, but the administrative procedure ends here, and the only, as I say, the only thing that this body has the authority to look at is the issuance of the building permit itself.
Mr. Huff?
I have a comment for the AT&T attorney. You correctly said that you did not have any public meetings, that AT&T did not reach out to the community.
Please forgive me, I'm having a hard time hearing you.
I said, you correctly stated that you did not have any public meetings or have any public outreach to the community, but said instead that you reached out because you made application to the Planning Commission. I'd like to pull them back out from under the bus just a minute and say that putting that on Planning Commission and saying just because you made application to the Planning Commission, you met any kind of, if not legal, but certainly appropriate public outreach is, my personal opinion, that's offensive.
It is.
Well, when we file an application, under normal circumstances, when there's a planning commission hearing or public hearing, we send out notice letters. We do that all the time. We do that in thousands of applications, but it's not required for this level 1 review under your ordinance, so we didn't do it in this instance. The other thing that I'm mindful of is that to do a tower is sometimes 18-month to 2-year process. And early in the process, we have agents or site acquisition consultants. They're people that go to take the PVA map, they look at that search area map, and they go into the field and they contact property owners. And they say that we represent AT&T, that we're looking for a site to locate a tower, and we want to know if you're interested. So, you know, that's probably the rumor mill that Mr. Denton is talking about. So we have contact with the community very early on in the process to let them know that we're coming in to put a tower in the area and speak to many landowners. They send letters out, they make phone calls, they do all kinds of things to see if they're interested in leasing space for a cell tower, as our landowner has done here. So the community does get notice of our plans to improve service in the community. And that's 9 times out of 10, that's triggered by customer complaints. So this is a synergistic whole here. I mean, you know, the question that was asked was, did we have something akin to a public meeting, you know, about this? And we did not do that in this instance.
I agree. You did not do that. However, you did state that by going through the planning process, those folks represent the community, and they should have taken the communities into consideration. And I gotta tell you, they represent an awful lot of people in Knox County, and they do not have the time nor the responsibility to do that. And I'm sure you sent out letters to property owners, probably this property owner, but sending a letter to a management company, LLC, located on Gay Street, is not going to get any information out to their neighbors. In fact, if anything, it's likely to keep it more secret.
I understand your concerns. I'm not standing here trying to argue with you. I'm just having a conversation with you about what the process looks like and what goes on, and that may offer some explanation for Mr. Denton's comments that they heard rumors that a cell site was going in very early on, and they started calling planning department with questions about it very early on. So they knew about this process for quite a while, and by their own. Anyway, I'm not here to argue. I'll stop talking.
Do you have a question, Ms. Garrett?
Actually, I just had one more comment, and this is to AT&T. You followed, crossed all your Ts, dotted all your Is. Planning Commission, in building, you guys did an amazing job. You guys did your job and did it well. And doing all that, you may have followed the ordinance to the letter, but that may be legal, but that doesn't make it right.
Can I let's ask a question. Could I ask opposition a question? Opposition? Okay. Sir, will you come back up to the podium for a moment?
The AT&T.
I'm sorry, who?
You.
Mr. Grant, come up
You.
to the podium.
So I think that you realize that the community was at a bit of a disadvantage. I know you said that planning, codes, whoever, were responsible for letting the community know this has happened. You have 15 days to make an appeal. We understand where everything is on the table with that. We got it. Would you be willing to possibly back up and say, you know what? This is one of those fluke situations, and we will give you the opportunity to file that appeal now, even though it has passed.
I don't have authority to do that from my client. If I were to say yes to what you just asked, I would get fired. I don't have authority to do that. And
What would it take you to get authority?
my client's not going to give authority for
Well,
that.
that's interesting. You're telling me you don't have authority, which suggests to me you haven't spoken to them, but now you tell me that they would not.
I'm here today because my client asked me to be here to oppose this appeal. That's why I'm here. My client made it very clear that they do not want this building permit revoked. So, I don't have authority to agree to give these folks an opportunity to appeal. In fact, just the opposite. I'm here to oppose that. Did that answer your question?
It did. I don't like the answer to your question, but I heard your answer, though.
I understand.
Yes.
We did,
Yeah.
we fully complied with your code. We did everything we were supposed to do. We worked really hard on this project.
I understand.
And we went through all the steps. We worked with your staff. We did everything we were supposed to do, and we did it to the letter of the law.
Yes, this is to both parts, to you and as well as to the community. Under the circumstances, Steve, AT&T met all the, they went through all the proper procedures. COA was granted. There was nothing in there that was out of ordinary or out of sequence. Everything, all I's dotted, all T's crossed. Even though everything is done, and according to the board, we have to go based off of the merits of if everything being met for the COA. This is a travesty, and I feel bad for the community. I feel like you all kind of backdoored the community, then trying to put the blame on Planning Commission, which is very unprofessional. Don't nod your head no, because that's exactly what was happening. This is on tape. So, but having said that, I'd make a motion to, without, we don't have any other choice but to dismiss the, deny the
Deny.
appeal, because the only thing we can base it off of is that all this, rules and procedures and standards that were supposed to be made were met according to, departments of codes and planning. We don't have a choice.
Second motion.
We have a motion and a second, and I am so sorry. To deny, yes, to deny the request of Joseph and Donna Denton for variance of the Knox County Board of Zoning Appeals to appeal the building permit 231577 for the cell tower. The building permit was completed the way it needed to be. So we have a motion and a second. All in favor? Aye. Opposed? One opposed? Two opposed? Let's do a roll call.
Mr. Brown?
Aye.
Mr. Repass?
Aye.
Mr. Lloyd?
Opposed?
Mr. Holt?
Aye.
Mr. Anderson? Aye. Ms. Kerr?
Aye.
Ms. Garrett?
No.
Ms. Longmire?
Yes.
Mr. Huff?
No.
6-3. 6-3, motion carries for the denial. So sorry. Truly am.
Motion to adjourn?
No, not yet. We've got our discussion in the bylaws today in our meeting, so we'll continue that next month, and I'll put together what we had discussed already to have that ready and continue it next month. Okay. Defer, add it to the calendar, keep it on the calendar? Yeah, carry it over.
Carry it over. Carry it over.
I move that we carry over 5A until next meeting.
6A.
6A.
Second.
All approved?
Aye.
Aye. Opposed? Motion carries. Meeting is adjourned.